Welcome friends. So today two things I would like to discuss. Number one, I will give you an overview of mega exemption list because we have to read and reread. You read number of times so that whenever a practical question comes or whenever some question comes, you should be in a position to do it comfortably because this is one of the most important areas. Second thing is about your examination syllabus, how to attempt, important areas, salient features, all these things I will discuss. The discussion is equally important for this coming examination, that is May 2016 examination. Of course, useful for those appearing in November also, because I expect that you would be clearing in May itself if you are appearing. Otherwise, those who are not appearing, of course, it's for November. Useful for both May and November examinations. I will give you the tips. Now, issue is, you know the background. Under section 93, government has been given power by parliament to grant exemption wherever and whenever it considers necessary in the interest of the public. Here mega exemption means full exemption, no partial exemption. So government has used the power and it has granted exemption as and when necessary, as and where necessary. Right now we have 47 entries granting exemption, and recent entries we have to be more particular about because latest amendments means very relevant for your examination. Important here is, just I will have an overview. So 1 to 47 I will go through anyway, and I will stop wherever necessary. Look at this first one. What about the first one? First one is services provided to United Nations organizations. Let us go to slide. United Nations organizations, services provided to means here service receiver is United Nations organizations. When the service receiver is United Nations organization, then what would be the position? Or tell me. First one is services to United Nations organization or other international agencies. Okay. The language here is specified international organizations. So what are the specified international organizations? Here two things you have to understand. This exemption is granted to a particular entity as a service receiver or as a service provider. That is important. Here provided to UNO means here UNO or specified international agencies, organizations are service receivers, not service providers. Okay, number one. Number two, in the negative list we have already seen. Do you remember? Under C, section 66D, clause C, services provided by means as a service provider by foreign diplomatic missions. What are they and what are these? Totally different. Foreign diplomatic missions are embassies, foreign ambassadors representing their countries, consular offices, embassies. They are representatives of each or different countries, American embassy, British embassy, etc. So whatever services they provide, they are under the negative list, not subject to any charge. What about the services received by them when they are service receivers? So they are not covered under the negative list. They are supposed to be paying service tax as a receiver, but at the same time there is a notification number 27 by 2012 in which their services as recipients, they were also made exempt, separate, other than mega exemption. They are not given in mega exemption, they have been mentioned specifically separately. So this point you should be clear. So that is different and this is different. You are here talking about United Nations organizations. You know what is UNO. It is different from these embassies. and specified international agencies, just like World Bank, just like World Health Organization. They have given a list. International Civil Aviation Organization, International Labour Organization, Food and Agriculture Organizations of United Nations, UNESCO, IMF, IBRD. Like that they have given a list. This is only an illustrative list, not complete. But in fact, you have to go through, should you go through the list, entire list? That's a big question. Specified international organizations, when you talk about, let me spend some time. Specified international organization, they have given the list, and the list is very long. Okay. So, but should you learn all these things, each and everything? To what extent can you really learn? Is it easy? Specified organization, specified international organization means an international organization declared ZF in the definitions under Megan exemption notification they have mentioned. It means an international organization declared by the central government in pursuance of Section 3 of United Nations Privileges and Immunities Act, to which the provisions of the schedule to the said act apply. So, central government notifies separately. Central government has notified. So, this is an illustrative list, and the list is longer than this. At least you understand these are the organs or limbs of United Nations organization. Just like World Health Organization or UNESCO or Children's, these things, International Monetary Fund, these things, International Labour Organization. So, if these organizations receive any service as a receiver, because services provided to, they are exempt. So, that way you try to remember. Okay. Second one is healthcare units. Services provided by way of transportation of a patient in an ambulance other than those specified in 1 above. This has been added by notification 6 by 2015. So, healthcare services by a clinical establishment, an authorized medical practitioner or paramedics. So, there is an explanation for them. Who is a paramedics? They have given an explanation. Simply speaking, health services have been exempt. If a doctor provides any service, that is exempt. But remember, services like plastic surgery, they are out of the purview. They are taxable. Okay. So, transportation of a patient in an ambulance other than those specified in the above. So, earlier what was there? Specified organizations or clinics, if they provide transportation of a patient, that was exempt. Now, even if I provide ambulance services, say there are so many so many companies which are providing free ambulance services, because emergency service. Ambulance service means emergency service. Some patient has to be rushed to a hospital or some other place immediately for immediate action, medical attention. So naturally ambulance services are provided. Even traffic rules they can violate. Even red light cannot stop the ambulance because of the emergency, because we have to save some lives. So here now anybody providing ambulance services for patients, that is free. And you have to link this with section 66D Q, last one, that is about funeral services. What is the difference here? Funeral services are with relation to dead body. The person is no more, no life. Once the life is gone, any service connected with the dead body or funerals, that is totally under the negative list. But at the same time here, it is about a patient, not a dead body. So if you carry a patient through an ambulance, whoever is providing the service of an ambulance, maybe he is charging, not free, he is charging, but still no service tax is payable on this. So that is what it means, number 2. And what is healthcare service that has been given here? You have to read carefully. Recognized system of medicines, etc. And it includes by transportation of the patient to and fro clinical establishment, but doesn't include air transplant or cosmetic plastic surgery. You should be very careful about this. Air transplant or cosmetic or plastic surgery. This is for glamour. The person is not going to die if he doesn't have air transplant. Is he going to die? No, he is not going to die. Okay? Cosmetic or plastic surgery. If he doesn't have it, in most of the cases, he is not going to die. But to enhance the beauty. So, except when undertaken to restore or reconstruct anatomy or functions of body inflicted due to congenital defects, developmental abnormalities, injury or trauma. What do you mean by this? Somebody was burnt, face burnt, and so many parts have been burnt, and this burnt portion repaired. It is covered under the mega exemption. Due to congenital defects by birth. Congenital defects means by birth. And if the doctor wants to repair that through plastic surgery or something like that, or development abnormalities, or injury or trauma because of some accident or some unwarranted situation, or something like burning injuries. So something is done to repair that. That is governed by mega exemption. Otherwise, cosmetic or plastic surgery or air transplant do not fall under this. So they become taxable. So healthcare services is both inclusive and exhaustive. This definition you have to read carefully. And about recognized system of medicines. See, they are granting exemption. With what intention the government has been granting? Not every type of medicinal system that it is allowing. Only recognized systems of medicines. What are they? Recognized systems of medicines include allopathy, this English medicine, yoga, naturopathy, ayurveda, homeopathy, siddha, unani. Any other system that may be recognized by central government. Central government anytime may recognize. So you remember this. Yoga is a part of it. Allopathy, homeopathy, naturopathy, ayurveda, siddha, these are a part of it. So you have to read them. And if any one is covered under this, or anything covered by central government, if central government issues a notification that we recognize that Reiki is a recognized system of medicine, then it will be done. But right now Reiki is not recognized. Remember, because Reiki is not recognized. So if somebody provides the service of Reiki and makes money, and he has to pay service tax because it's not covered by mega exemption. Okay? And authorized medical practitioner means registered with any of the councils of the recognized system of medicines. And clinical establishment also has explanation. This you have to go through. You have to read. Paramedics means trained health care professionals. For example, nursing staff, physiotherapists, technicians, lab assistants. These are trained people. These are called paramedics. So, thus paramedics need not be medical professionals possessing professional qualifications. This you have to know, you have to read. Then exempted services 2A. The services provided by cord blood banks by way of preservation of stem cells or any other service in relation to such preservation. Cord blood banks, this is a very big business. If you are interested, go for a Google search, you will find out. So, these are somewhat in connection with childbirth, etc., womb, etc. So, cord blood banks are there and they provide services, the very good service, stem cells, they preserve the stem cells, and these are granted exemption. These have been granted exemption. I think last year the government has done it. I think 2014, 13 or 14. You have to, if you don't want to go deep into things, just learn. Cord blood banks, you remember this word. Stem cells, you remember. That's it. It's exempt. Because even the paper setter, examiner, will use the same language. Suppose you have read it twice or thrice, you remember that. If you find the same thing in the examination hall, in the question paper, automatically you will take it that this is exempt. Okay. Sometimes going deep into things is also unnecessary. Right. 2B. This was also a newly added thing. So services provided by operators of common biomedical waste treatment, clinical establishment by way of treatment or disposal of biomedical waste. I think recently 2014 or 15 this has been added. So common biomedical waste treatment or clinical establishment by way of treatment or disposal of biomedical waste. Rightly they deserve exemption. Service tax should not be collected. They are doing a lot of service to protect the environment. Okay. So then services by a veterinary clinic. Veterinary clinic in relation to healthcare of animals or birds. You know, veterinary doctor, that is for animals and birds. So when medical doctor for human beings, you are exempting, obviously, naturally, a doctors treating animals and birds their services should also be exempt. And because the environment is a part of flora and fauna, not only human beings. See, human beings plus all living organisms, mainly animals and birds, they are a part of this environment. And trees, vegetation, part of environment. So to protect, see, a human being can well be protected only when there is a balance in the nature. Animals, birds, vegetation, plants, trees, etc., everything are in balanced position. Otherwise, it's not possible for survival. Survival becomes difficult. One living organism is dependent on the other. So that's the reason why. So Finance Act 2014 added this, and this is also exempt. And number 4. Services by an entity registered under section 12AA. And about this I discussed a little more elaborately earlier also. I don't think this requires more elaboration, just briefly I will go through. This is section 12AA of Income Tax Act, you know, charitable activities. Charitable activities. So charitable entities, they have to get themselves registered under section 12AA of the Income Tax, otherwise benefits will not be there. And that is a prerequisite to claim exemption under this also. Suppose you are a charitable organization, but you are not registered under section 12AA, you don't get the exemption here. So what is the requirement? Entity registered with these income tax authorities, and entity carries out one or more of the specified charitable activities. What are the activities that the charitable entity, registered charitable entity should carry? So two things you see, take care of two things. Number one, it should be a charitable entity registered under the Income Tax Act. Number two, it should carry out the specified activities. The activities have been given here under mega exemption. So that is to be taken care of. So it is not covered under the negative list. Okay. Meaning of charitable activities. This is very important. Already we discussed at length, and just to go through. Number one, public health by way of public health. So they have given under part A three areas, 1, 2, 3. Care or counseling of terminally ill persons or persons afflicted by HIV, AIDS, or addicted to a dependence forming substance such as narcotics, drugs, those who are addicted to narcotics, drugs, drug addicts. So then part B, this is public awareness of preventive health, family planning, etc., advancement of religion or spirituality, etc., and advancement of educational programs or skill development relating to these key categories, which we have already discussed anyway. Preservation of environment including watershed, forest and wildlife, obviously these are necessary. And look at this one, fourth one, advancement of any other object of general public utility, this has been done away with. This is no more. You don't need to read this. By mistake it was printed. Next, fifth one. So first four you understand. One is United Nations organizations or others, and there is a list. If they receive services, they are exempt. And 2A, what are the 2 and 2A? Go back, let's go back to see what is 2A, and that is about healthcare services, right? Healthcare services. Let me read out for your benefit. Mega exemption. Number 2 is healthcare services, and number 2A, blood banks, that is preservation of stem cells. Cord blood banks, stem cells 2A, and 2B, services provided by biomedical waste operators, biomedical substances, and 3, already see we have seen veterinary doctor, veterinary doctors services relating to animals and birds. 3, C, number 1, United Nations organization, that is totally different. Number 2, medical services, and number 3, medical services relating to animals and birds. And 2A and 2B were insertions. One is blood banks, preservation of stem cells, and also common biomedical waste treatment facility. They are also relating to medicine, drugs and medicines. Okay, and now fourth one, charitable entities, charitable organizations registered under section 12AA. And after charities, fourth is charities, after 4 it is religious places or ceremonies. 5, services by a person by way of renting of precincts. On this we have got practical question also. Meant for general public, renting of precincts of a religious place like temples, ashrams, etc. If they collect rent for general public, meant for general public, or conduct of any religious ceremony. If they are meant for general public or for any religious ceremony, then to that extent it is exempt. Okay, religious place means primarily meant for conduct of prayers, worship, etc. General public means body of people at large sufficiently defined by some common quality of public or impersonal nature that has been there. Religious ceremonies means life cycle, rituals, etc. they have explained. And 5A, please read this carefully because this has been added recently, recent edition. Religious pilgrimage facilitated by the Ministry of External Affairs under the bilateral agreements. So, you see, Hindus go to Amarnath Yatra. There is an organization, Kumayun organization. And similarly, Hajj pilgrimage for Muslims. So, very, very important thing for Muslims. So, for Hajj pilgrimage, there is an organization. And whatever services they provide, even if they collect some money, Hajj pilgrimage, no service tax is collected, that is exempt. Similarly, Kumayun organization, that organization has been there. Services provided by, they have given the name, of course, their services are exempt. Hajj pilgrimage, related services, organization providing services to Hajj pilgrimage, government has already announced. And also with regard to Amarnath Yatra, both are equally important, for the two different religious groups, for Hindus and also for Muslims. So that has been granted exemption, that is 5.1. And look at 6, legal services. You can expect a practical question on this also. I have already discussed in the last lecture about 3 parts: arbitral tribunal providing services, individual or advocate or firm of advocates providing services, and a person who is represented on an arbitral tribunal to an arbitral tribunal. So arbitral tribunal to arbitral tribunal, these 3 categories are exempt. I have already explained this. What is legal service? You know that. So, but what is important is 10 lakhs. If it is a business, if it is a non-business entity, no service tax. If it is a business entity receiving services and its turnover should be above 10 lakhs. Otherwise, no service tax. Okay. And then exempted services versus services. Number 7, this is no more. Technical testing or analysis services. These technical testing and analysis services have been done away with. Now it is taxable. Earlier it was exempt, now it is taxable. Specified organization shall mean, because we were discussing that entry number, which one? Entry number 5A. So for entry number 5A, there is an explanation. Specified organization here means Kumaun Mandal Vikas Nigam Limited, that is Government of Uttarakhand undertaking. Committee of or State Committee as defined under Section 2 of Hajj Committee Act. Hajj Committee. So this is for Hajj pilgrimage and this is for Amarnath Yatra. 8. Recreational coaching or training. You should be very careful here. 8 and 9, particularly 9 for educational institutions. Recreational coaching or training, I have already discussed at length these things. So it should be a recreational or coaching or training with regard to 3 things relating to art, culture or sports. These are examples. So what is recreation activities? Very wide, but it should be confined to these 3 only. And then 9 education services. This also I have discussed at length just to give you an idea, reminder. So by an educational institution, SFS, students, faculty and staff. If service provider is an educational institute, all services provided by them to these 3 categories are exempt, and if it is a receiver of service, only these are exempt. What are they? TCS formula, TCS AE formula. T means transport, C means catering, and S means security including cleaning, housekeeping. Okay, and S here means security. A means admission and E means examination. Services relating to admission or examination, whatever services it receives, whatever services an educational institution receives, that is exempt. And anything other than these 4, if an educational institution receives, that is not under exemption, service tax is payable. And one more thing I would like to remind you, here educational institution means an institution which is eligible under negative list, means which is providing non-taxable service as per negative list. Not all educational institutions. You are getting my point? For example, a senior secondary high school. A senior secondary high school, say it is run by government or private, it doesn't matter, or recognized, and it is providing educational services. It is running the school up to 12th class, 12th standard. So up to 12th standard it is under negative list. And if it receives any of these services, or a college or a university, if it receives any of these services, TCS AE, then it is exempt. If it provides services to its students, staff or faculty, then also it is exempt, otherwise no. So you should be very careful about entry number 9. When you read entry number 9, you should take care of this. And what about entry number 10, sports services? To a recognized sports body, very important. If you provide service to a recognized sports body, if a recognized sports body provides a service as a service provider, it is under the negative list. But if it receives, then what happens? Even if it receives, it is not liable to pay tax because of the exemption. It should be a recognized sports body. So provided by an individual as a player, see status, as a referee, as an umpire, coach or team manager. So their roles are very clear. You are providing service to a recognized sports body. Suppose you are a supplier of breakfast, you are providing catering services, because for the team, ande, eggs, mutton, chicken, you are providing, supplying, and you are providing catering services, or you are supplying milk to them. Do you say that you are providing these services to recognized sports body and you should be exempt? No. So you should be as a player, referee, umpire, coach or team manager. They have clearly mentioned the role. Then you are exempt for participation in a sporting event. Another, say somebody service provided to recognized sports body by another recognized sports body. Sports body to sports body and individual to sports body. But individual, he has status. Player, referee, umpire, coach, team or manager. Not as anybody else. Okay? So you have to read, you have to remember these terms, no? As a player, as a referee, as an umpire, as a coach or as a team manager. Anything other than this? Sorry. Then what is a recognized sports body? That has also been given, you have to read carefully. Okay? See, look at this. Services of a player to a franchisee. No, it is taxable. Sports body to another recognized exempt, it's okay. Such as selectors, commentators, curators, technical experts, taxable. So some commentator, cricket commentator, selector, curator, technical experts. What about these services? They are taxable because he is not as an umpire, player, referee, or you can say team manager. You are not a team manager here, you are a selector. So that you have to. So service of an individual as an umpire, referee, etc. Okay. What is a recognized sports body? See, Indian Olympics, there is a list. You have to read. You need not learn. You have to read to recognize in the examination hall. Next, 11th one. Sponsorship. This is about sponsorship. Somebody is providing services to a recognized sports body that is governed by entry number 10, right? But here entry number 11 is about sponsorship. If I sponsor a sports event, then what happens? Sporting events. So it should be by a national sports federation or its affiliated federation. If it is provided by, if the service provider happens to be these categories, or by Association of Indian Universities, etc. Or by, look at this, by means these are provided by, here Central Civil Services Cultural Sports Board, it is the service provider, it is provided by as a part of national games. See, under Panchayat Yuva Krida or Khel Abhiyan. So these are the listed ones. If these organizations provide service provided by them, then service tax is not payable, that is exempt. Next, services received by government. Services provided by government are in the negative list, barring a few exceptions. Now, what about the services received by government? So, provided to the government means here government is a service receiver, local authority or governmental authority. Even governmental authority has been given definition. What is a governmental authority? It is performing the functions of a local authority, so municipal functions, but where government or state or central government has 90% or more than 90% stake in it, in the form of equity or otherwise. Okay. So by way of construction, erection, commissioning, installation, completion, fitting out, repair, etc., etc. Here also there is a catch. You have to be very careful. Services provided to government or local authority or governmental authority, it is okay. What type of services they have given? List. Services list has been given. So if anything else, then it becomes taxable. You see, they are talking about construction, erection, commissioning, installation, and fitting out, repair, maintenance, renovation. See, right from construction to repair and alteration. So all these things are somewhat connected with construction or repair, reconditioning, etc., etc., renovation, etc., etc. If this type of services are received by government or any of the three organizations, then suppose you talk about RBI. Is RBI governed here? No, because RBI is not a government. It's a separate body corporate, a separate legal entity. So if RBI receives any of these services, it has to pay service tax. Okay? That too specified services, you have to read the specified services. And in this I think I call it very important. Why I call it very important? Because here there are amendments. See, these three organizations, government, local authority and or governmental authority, these three categories, there were as many as 6 services which were exempt earlier. Now the list has been reduced to 3 only, and the remaining 3 now have become taxable. What are they? First one, civil structure or any other original works meant predominantly for use other than as commerce, industry or any other business entities or profession. So if it was there, now it is taxable. Now it is taxable for use other than for commerce, industry or any other business or profession. Let me verify. Yes. So now it is no more. So now it is taxable. Read it carefully. When you read from the material, you should be very careful about this. This is no longer. And B, historical monument, archaeological site or remains of national importance, archaeological excavation, etc. This is still there because this is about historical monuments and archaeological sites. So that is still exempt even today. And what about this? A structure meant predominantly for use as educational, clinical or cultural establishment. I have already covered this. Suppose government wants to have a hospital built for poor people, free medical services. So, sorry, now it is taxable. C, now it is taxable. But D, canal, dam or other irrigation works, yes, even today it is exempt. Pipeline, conduit, say water supply, water treatment, sewerage treatment or disposal of wastewater, yes, this is still exempt. But residential complex, this I have already explained to you. Sorry, say member of parliament or their staff or staff of the government, there are some construction activities. Now they are taxable. So now BDE are taxable and ACF, sorry, BDE are exempt, ACF are taxable now. Earlier all the 6 were exempt, now only 3 remaining and 3 became taxable. And what about the 13th? So these ones are very important. Services provided by way of construction, erection, etc. Fitting out, repair, the same thing is repeated here. What is there under entry number 12 is there under entry number 13 also. What is the difference here? Tell me what is the difference here? There is a difference. These were the under entry number 12, the services were received by 3 entities: government, governmental authority or local authority. Here common, by in general, anybody. These services may be received by anybody. Even if I receive these services, if the services are provided by anybody to anybody, not to specified entities, even if somebody provides services to me, the listed services here, that is they are exempt. Even if I provide service to somebody, not necessarily government, that is also exempt. But these services are specified. So with reference to alteration of what? Road, bridge, tunnel, terminal, etc. because this is meant for public transport. And civil structure other than or any other original works pertaining to scheme under Jawaharlal Nehru National Urban Renewal, etc. Rajiv Awas Yojana, and a building owned by an entity registered under section 12AA, charitable organizations. If the charitable, if you provide service to charitable organizations in, say for example, construction of a building, yes, it merits exemption. And pollution control, effluent treatment, this also gets exemption. Okay. And what about 14th one? Services by way of construction, erection, etc. Installation of original works. What is missing here? So out of 13 and 14, if you compare, something is missing here. Is there anything relating to repair, fitting out, maintenance? Is it there? No. So the services are restricted here. Only erection, construction, or something relating to original works. No repair, no maintenance, no fitting out, etc. But provided to whom? Specified categories here. Read and reread, then you will be able to appreciate the difference. So earlier, airport and seaport, they were getting exemption. Now, no, sorry. If these services are provided to airport or port now, they become taxable. They are taxable now. But still, who are enjoying? Railways are enjoying. Monorail or metro rail, they are enjoying. Single residential unit, you know this. Low cost houses, they enjoy. Carpet area of 60 square meters. And poverty alleviation program, etc. is there. Post harvest storage, this is relating to agriculture. So when you read section 66D, clause D relating to agriculture, and you have to read this also together with agriculture. So what is it they are exempting here? Post harvest storage infrastructure. After harvest storage for agricultural produce, including a cold storages for such purposes, and E also mechanized food grain handling system, machinery, equipment for use for units processing agricultural produce as foodstuff, excluding alcoholic beverages. You see this? These are relating to agriculture. So when you read agriculture, you remove these two things and add there and read together this agriculture portion. Okay. And 15th one, exempted services versus services included in the negative list. Services provided by way of temporary transfer. You know, here this is about intellectual property rights. You have to read carefully. Section 13(1). Original literary, dramatic, musical or artistic works. Original. Original means I write a book. I have a stage performance. I record classes. Or I sing a song. I have a painting. All these come under original literary, dramatic, musical or artistic works. So these are exempt. If I lend away, if I give a book, if I write a book and give it away, that is non-taxable. So section 30, based on this you will be getting some practical questions also. Under Copyright Act, only Copyright Act. If it should be original one, I make a design to construct a building, a structure, a studio. I have designed a studio as an architect. That is my original work, covered under Copyright Act. If I transfer it to somebody on a temporary basis, of course, if I transfer on a permanent basis, it is a sale. No sales. It is a sale and sales tax is payable. No service tax is payable. But if I do it, transfer by way of transfer on a temporary basis, if I give license to use, then it is covered under service tax. Okay, so that is exempt. And cinema films, exhibition in a cinema hall or cinema theatre, only in a cinema hall or cinema theatre. Otherwise, no. Because if it is performed in a cinema theatre or cinema hall, entertainment tax is being collected, and the government does not want to vex, government does not want to punish more by taxes. So state government is collecting entertainment taxes anyway. Central government doesn't want to collect any service tax. If it wants, it can, but it is not doing. Okay. Section, see, entry number 16 again I call it very important because redrafted. It has been redrafted. What is it? See, folk or classical art, forms of music, dance, etc., or theatre. So, if it is a service by an artist, some artist is providing service. Try to get this, very important. Some artist is providing the service, okay, by way of performance in a theatre, or folk dance, or classical art forms, etc., 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 ballets, etc., and that is linked with the consideration. If the consideration for such performance is not more than 1 lakh, means up to 1 lakh, if his consideration is up to 1 lakh, it is okay, it is exempt. If he is collecting more than 1 lakh, if the charges are above 1 lakh, sorry, even if it is a folk, classical art forms, music, etc., etc., that attracts service tax, then on the entire amount the service tax is collected. For example, say you may get some practical questions like this. Somebody, folk dance, maybe you heard of Kuchipudi dance. Kuchipudi dance. It's a variant of Bharatanatyam developed in the state of Andhra Pradesh. It's a part of classical art. Kuchipudi, and the speciality with the Kuchipudi dance is most of these are performed by gents, not ladies. Gents wear ladies' dress and they dance. If you see them, you find that they are ladies. They are not gents. But after that, if somebody tells you that it is not a lady, but it's a gent, then you will admit, oh my goodness. That is Kuchipudi dance, like Bharatanatyam, performed mostly by gents. This is also world famous, and this is provided by this is performed by somebody, Mr. X, say Vedanta Satyanarayana Sharma. Vedanta Satyanarayana Sharma, let us say, and he is paid 5 lakh rupees per performance, per night. So now entire amount is taxable. Suppose he is paid only 1 lakh rupees, not more than 1 lakh, up to 1 lakh rupees, no service tax. If it is more than 1 lakh, say for example 1 lakh 10,000 rupees, on the entire amount of 1 lakh 10,000 rupees service tax is paid. And what about if that service is provided as a brand ambassador? Sorry, this limit is irrelevant. Even if he collects 1 rupee, on that 1 rupee service tax is paid. Brand ambassador services are taxable. The amount they charge is notwithstanding, it is irrelevant. Done? So what about, look at this, just you can go through what are taxable and what are not taxable that have been given. I don't want to spend time on that. 17, entry number 17, services by way of collecting or providing news. You know, see, news channels, newspapers, they are backbone of democracy. Without them, there is no democracy. Obviously, we don't want to collect any tax on their services. So, 17.1. And 18 hotel services. I have already covered these hotel services. You know, hotel services, whether you call it declared tariff, this is based on tariff. It should be below 1000 rupees per day, per unit or per room. If it is 1000 rupees or more, 1000 or more means it becomes taxable, but there is an abatement. There is an abatement. And you pay tax after deducting the abatement amount. Right? Declared tariff, I have already explained this. I will move. Declared tariff includes charges for all amenities provided in the unit of accommodation, etc. Read this carefully. And entry number 19. Services provided in relation to serving of food or beverages by a restaurant, etc., eating joint, etc., etc. These are under the negative list. So having the facility of air conditioning or central air heating, So remember, hotels, restaurants, etc., etc., whatever they provide, of course, subject to uh, exemption limit, small service providers exemption limit of 10 lakh rupees. Subject to that limit, the facility of air conditioning or central air heating, if it is provided even in a part of the establishment, okay, even if a part of establishment, if they provide air conditioning facility, then it becomes taxable. And a license to serve alcoholic beverages is not necessary now. Now, it is not necessary that they should have a license to serve alcoholic beverages. That you have to be very careful about. Say, entry number 19, that has been omitted. That has been omitted. Now, it is not necessary to have a license to serve alcoholic beverages. Even if you don't serve alcoholic beverages, if you have air conditioning facility, you have to pay service tax. If your limit in a year is about 10 lakh rupees, you know that. Okay. And 19A, factories. What about factories? They have done it. Even if they have air conditioning facilities in a factory canteens, they are exempt. Because in factory canteens they don't want to, because they are not meant for the public, they are meant for the factories, so they don't want to inflate the cost. So if such a facility is provided in factories, beverages by a canteen maintained in a factory covered under the Factories Act, having the facility of air conditioning or central heating at any time during the year. Now the question is, ICAI New Delhi has a canteen facility. Obviously, you must be knowing it. In regional offices also, branches also, their facility might be there. The ICAI has a canteen facility, and in that canteen they have air conditioning facility. In Delhi, temperature is very high in the months of April, May, June, July, August. 4 months. April, May, June, July, August. April, May, June, July, August. 5 months. Okay. So, is it covered here? Sorry. So, look at entry number 19. It says, in a restaurant, eating joint or a mess, anything other than those having facility of air conditioning. If they don't have facility of air conditioning, that is okay. But ICAI canteen is having this facility, air conditioning facility, then service tax is payable for the services, for the foodstuffs served by them. That is, you have to pay, 40%. 40 on the 40% value. If sales tax and service tax both are collected. Okay? You try to understand, try to see the difference. 20. Transportation of specified goods by road, rail, vessel, etc. So, 20 to 25. Again, very important, you have to read carefully relating to transport and also government related services, etc., etc., which we have to see. Let us see entry number 20 and 21. You should be very careful. There is some confusion in the language written here. So entry number 20 and 24, they deal with the transportation. So very, very important entries, because from examination point of view, what type of transportations are exempt? Public transport mostly exempt. Even transport of goods by road exempt. You know that. Unless it is through GTA. If the transport is through GTA services, then it is taxable. Otherwise it is no. Unless it is courier service, unless it is a GTA service, it is in the negative list. But there are certain transports which are taxable, and for them also there is some exemption. They have given a list of mega exemption. Entry number 20 and 21 deal with that. So I read the text also. From text also I will verify, because there is some mismatching here in the language. Entry number 20, for example, Entry number 20 is talking about services by way of transportation by rail or a vessel from one place in India to another of the following goods. By rail or vessel. By rail or vessel, these are the things entry number 20 talking about. But this road, GTA, that is 20, entry number 21 is talking about. When you read, you should read carefully. So entry number 20, I repeat, deals with transport of goods by specified goods because the list is there. By road, by rail or vessel. Vessel means ship. But road is governed by Rule 21, that is relating to GTA services. So here it is mixed up, actually you have to read carefully. Following enumerates the goods transportation of which is exempt from service tax. What are they? Here they are talking about goods transport agency. So there is a mix up. Mostly all these items are common. That is the reason why they have been mixed, clubbed, but there is some technical error. So that is what I want to tell you. I read out, for example, by road, by rail or by road. See, by rail or vessel, let me read first. So earlier petroleum products etc. were there. Now they are taxable. Carriage of petroleum products. Next, now it is available. What is available is relief material. Relief material is there. Entry number 20. Relief material meant for victims of natural or man-made disasters. Defense material. Okay. So defense or military equipment is also there. Okay. And then these numbers are relevant for entry number 21, not 20. Postal mail or bags now taxable. Household effects now taxable. Earlier they were exempt. Newspapers or magazines. Look at this. Newspapers or magazines. This is also there. Railway equipment or material specific to railways. Railway equipment or material specific to railways. Railway equipment. I write here. Railway equipment, material, etc. And then what else have they have given? Next, agricultural produce. So this agricultural produce is common. These are also common to Rule 21. Okay. So agricultural produce, where do you find agricultural produce? Here it is. It is there in 20 and 21 also, these things. And then milk, salt and food grains including flours, pulses or rice. Here there is something wrong with this. Food stuff is no more. So instead of food stuff, what is it? They have given milk, salt and food grains. It is food grains, not foodstuffs. If you say food stuff, everything eatable becomes a food stuff. Even sweets are food stuff, but they didn't mean so. Food grains, and next they say including flours. It is there. Tea, coffee, jaggery. These are not mentioned. Pulses and rice. Milk is there. Salt and edible oil, no. Salt is there, and in addition to salt, what else is there? Say food grain including flours, pulses and rice. Salt and food grain. Salt is there. Edible oil, it is not there. Alcoholic beverages, it is not at all there. Alcoholic beverages, excluding, of course, we need not mention this because alcoholic beverages are not covered. Milk is covered, salt is covered, food grains covered, and flours are covered. Pulses are covered, pulses and rice. So you read this carefully. This is covered. This is common to entry 21 also, that is dealing with GTA services. Okay, so this you read with the difference. And cotton ginned or baled, that has been given, but we have to check up. Cotton, I write here, cotton ginned or baled. See, baled cotton, ginned cotton. Cotton is ginning, seeds are removed and put under a proper process, that is called ginned cotton. Baled means they have put in containers, bags. They are in bales, cotton bales are there. So if it is ginned and baled, it is not a primary, that not meant for primary market, not an agricultural produce. Raw cotton is an agricultural produce. It need not be an agricultural produce here. Ginned baled cotton is now exempt. Rice is also exempt. Please take care of this. Please take note of this. Okay, cotton ginned or baled. What about chemical fertilizer, organic manure and oil cakes? Where are they? Chemical fertilizer, oil cakes, here organic manure. So now these are there both common to entry number 20 and 21 also, even for goods transport agent. And specifically, what is specific to goods transport agent? Look at this. Where the gross amount charged already you know, this is relevant for GTA. This is relevant for GTA. Okay? And single consignee 750 rupees. This is also relevant to GTA. These are specific to GTA, which are not there in entry number 20, whereas others, these are specific to GTA. So entry number 20 and 21 deal with the transportation of certain things, mostly common, except that railway equipment is specific to vessels and rails, trains, that is not specific to goods transport agency, number one. Number two, goods transport agent 1500 and 750 limits, these are there only under entry number 21 relating to GTA, not there in entry number 20 relating to transport by train or by rail or vessel. So you read this carefully, you should be very careful about. So or you get the Bare Act, and from the Bare Act you try to read this. So because these are very important. Entry number 20 and 21. 22, 23, when you are giving on higher basis, when you are giving on higher basis, this I have already discussed in the last. Okay. Here, if you give it to transport, state transport undertaking on higher basis. In fact, state transport undertaking is not a government, not a governmental authority, not a local authority. It is independent statutory body. So the state transport undertaking, if it hires to that extent, service tax is not payable. That is 22. 23. Transport of passengers with or without accompanied belongings. That is also there. But what is there in 23? I already discussed this now. Transport of passengers without belongings by air, embarking from or terminating. This is specific to state of West Bengal, Sikkim and Northeast regions. Air transport, specifically given to only those people, those areas. To and fro, no service tax. Contract carriage, already ropeway, cable car, aerial tramway, these are exempt, already discussed. No? And 20, 25, very important, again 25. So in 25, you know 24 is no more services by way of vehicle parking. This has been made taxable now. Earlier it was under exemption, now it is taxable. So parking lots, wherever they are, whether they are provided by public authority or private authority, or whether they are meant for the general public or not, it is totally irrelevant. The parking facilities are taxable now. Entry number 24 is no more. That has been removed. Entry number 25, services provided to government, a local authority or a governmental authority. Say government, local authority or governmental authority. Provided to. What do you mean by to? Here service receiver. So somewhere else also we have seen this phenomena. Services provided to government. Do you recall that? What are they? Construction services, repair, reconditioning, fitting out. Do you remember that? Services. So entry number 12 and 13, 14. But entry number 12 is relevant. Entry number 12 is talking about these three: government, local authority or governmental authority. That is about construction, repair, etc. Provided to. There also you read this. Services provided to government. Right? Here also services provided to government. A local authority or a governmental authority by way of carrying out any activity in relation to function ordinarily entrusted to a municipality: water supply, public health, sanitation, waste management, slum improvement, upgradation. So their repair, maintenance, construction, etc. were exempt if they are provided to any of the three. Here municipal activity related, public health related, supply, sanitation, public health, etc. Slum improvement, upgradation. So we have to read these entry numbers 12 and 25 together. What are the services received by government, governmental authority or local authorities which are exempt? So B, repair, maintenance of a vessel. So what was, it was there under entry number 25. Let me tell you, it's an important area. The repair or maintenance of a vessel. What is omitted? Repair and maintenance of a vessel. What about aircraft? Aircraft was also services. Repair maintenance of aircraft was also exempt earlier. Now it is not exempt. Only omitted. This has been omitted. Now only vessel related repair or maintenance is exempt. If it is a repair or maintenance of an aircraft, then it is taxable now. Earlier it was exempt, now it is taxable. So this is important point. And in 26 there is a list of insurance services. You have to read number of times because some question may be asked from them. There is a list. Okay, these are insurance services. What about entry numbers 26A? 26A has a list. What about 26A? I look at 26A is missing here. Directly 26B is given. Sorry, you have to read 26A also. Check up. And in 26A, services of life insurance business, they have given certain schemes, insurance schemes. Right? So those schemes they have exempted. For example, this time there was a question. Life micro insurance. Practical question I have already solved. Maximum amount 50,000 per policy. So 50,000 rupees. If it is above 50,000 rupees, it is taxable. So that has been added recently. Read entry number 26A also. 26B is also about insurance. Atal Bihar, Atal Pension Yojana, etc. etc. In the name of Atal Bihari Vajpayee, our ex-Prime Minister. Entry number 20C, earlier also it was there, it is about an incubator up to a total turnover of 50 lakhs, because incubator means somebody who is experimenting, who is doing something like research work, and he may or he may not succeed. But the person who is experimenting with his project or venture, initially he should be given encouragement. So they have given the encouragement up to certain limit, that is 50 lakhs turnover. Incubating means an entrepreneur located within the premises of a technology business incubator, science and technology entrepreneurship park recognized by so and so. Incubating, they have given the explanation also. And 28 is unincorporated body or non-profit entity registered under any law to its own members by way of reimbursement of charges or share of contribution as a trade union, etc., etc. These are also exempt, and under this your welfare association up to an amount of 5,000 per month per member for sourcing of goods or services from a third person for the common use of its members in a housing society or a residential complex. See, on this also you got a practical question this time, 2015 November. So this entry number 28 is also so very good, very important. If it is above 5,000 rupees, then it becomes taxable as per the notification given by government, circular given by the board. Entire amount becomes taxable. Suppose it is 5,500. It is entire 5,500 is taxable. You do this carefully. 29. Already we discussed at length these things. Earlier, these mutual fund distributor, etc., were also exempt. Now these are taxable. C, D, E are now taxable. Entry number 29. And 30, job worker. You know, job worker related. The job worker related is also very important. What are the things relating to job worker which are very important? In job worker, alcohol for human consumption. Earlier, job work process relating to alcohol for human consumption was exempt. Now C. Now that has been removed. C, any goods on which appropriate duty is payable by the principal manufacturer. Only this much. There is no mention of alcohol for human consumption. So that is taxable now. Entry number 30, to that extent you have to read. And exempted services versus services included in the negative list. Business exhibition held outside India. Say, you be careful about entry number 31. An organizer, any person, need not be a foreigner. Business exhibition held outside India are exempt. Services by an organizer to any person in respect of a business exhibition held outside India are exempt. How you should link these two? For example, rule number 6 of POPSR. What is rule number 6 of POPSR? It says if an event is conducted, then the place of provision of service shall be the place of event. Suppose some road show has been conducted in Chicago, America, USA. So the service is said to be provided in Chicago. Beauty contest has been conducted in Nagpur. So the service is said to be provided in Nagpur. So place of event is to be taken as per rule 6. But here there is an exemption. If there is a business exemption, be careful, you see, business exemption. And if it is held outside India, who is the service provider? Who is a service receiver? Irrelevant. If some organizer provides business exhibition service outside India, then it is exempt. It is taxable, but it has been exempt under entry number 31. So telephone calls, free calls, etc., now it is not possible. Now they are taxable. Entry number 32. Read this. Services by way of slaughtering of animals, that is already there. Services received from a provider located in non-taxable. This again I'll take entry number 34. I consider very important. Some questions sometimes came in CS professional examination also based on this. What are the services? Received from a provider of service located in non-taxable territory. Here they are talking about non-taxable territory. They are not talking about outsider or foreign destination. Means Jammu and Kashmir plus foreign destination. So if you receive service from a person from Jammu and Kashmir or from a foreigner, then what happens? So certain categories they have identified. Who? Person in non-taxable territory. 2. Number 1, government. local authority, etc. Government, local authority, or an individual in relation to other than commerce, industry or business. So personal purpose, government or individual for personal purpose, not business purpose. Or section 12 AA wala. Section 12 AA, you know, charitable organizations are located in non-taxable territory. So, person located in non-taxable territory. So, non-taxable territory, even if it is Jammu and Kashmir, it is okay. So, these are exempt. What would be the implication? Let me give you a few examples. For example, suppose there is an immovable property. You try to get it. No need to find writing. Suppose there is an immovable property in Bangladesh and service provider is from Bangladesh, service receiver is in service receiver is in India. So one is in taxable territory, another one is non-taxable territory. Property is located in Bangladesh. So as per rule 5, obviously location of property, service tax is not payable because immovable property is located in Bangladesh. This is what we study under rule 5 of POPSR, right? Suppose service is provided in non-taxable territory. Maybe let us take an example. The property is located in Mumbai. It's very simple. Property is located in Mumbai and real estate agent is located in Bangladesh and owner of the property is located in London. As per rule 5, location of immovable property we should say, so that becomes taxable because immovable property related service, location of immovable property is relevant because the property is located in Mumbai, service tax is payable. But you look at the parties, service provider is from Bangladesh, he is a non-taxable territory, service receiver is in London, he is in non-taxable territory. Non-taxable territory to non-taxable territory. By virtue of this entry number 34, this becomes exempt. A person located in non-taxable territory, service provider is in non-taxable territory and service receiver is in non-taxable territory. If provider and receiver both are in non-taxable territory, no service tax is payable. No matter. So, how much important it is? So, public libraries, entry number 35, employee state insurance 36, services transfer of going concern 37, public conveniences, you know, these are naturally they deserve, and services by governmental authority by way of activity in relation to function entrusted to the municipality. You see, a function entrusted to municipality under Article 243W. Say if the governmental authority does it, that is also exempt. Entry number 40, loading, unloading, packing, storage. So very important. Say loading, unloading, packing, storage or warehousing of rice, cotton, ginned or baled. Ginned or baled cotton, not raw cotton. If it is a raw cotton, loading, unloading, packing, storage is under negative list 66D. But rice is not an agricultural produce, so it is not under, rice is not under negative list. Rice is taxable, but it is exempt here. Rice is not on the negative list. Now cotton, ginned or baled cotton is not in the negative list, but it is in the exemption list now. Loading, unloading, packing, storage or warehousing. Already we have studied, we have seen entry number 20 and 21. Their rice and cotton bales, transport was also exempt. Transport was made exempt in entry number 2021, whereas in entry number 40, loading, unloading, packing, storage or warehousing has been exempt. This was made in 2014 to meet the pressure, because there was a pressure from Western India and Southern India, so they have got it. Okay. Services received by the Reserve Bank of India, you know this, in relation to management of forex exchange reserves. Only The only service received by RBI is exempt. All other services received by RBI are taxable. 42. Services provided by a tour operator. I have already explained this. Tourist in relation to a tour conducted wholly outside India. See, tour operator may be Indian, but service receiver is a foreign tourist and tour is conducted outside India. Then, sorry, no service tax is payable. Common affluent treatment. Recent. These are recent editions. So, from entry number 40 onwards, they are very important and you have to read. Services by way of preconditioning, pre-cooling, ripening, waxing, etc. This is where essential character is not changed. This is now exempt. Earlier it was not there. Admission to museum, etc. Tiger Reserve or zoo. Now it is exempt because entertainment events are taxable. Na? To this extent it is exempt. 46. Exhibition of a movie by exhibitor or distributor to an association. Exhibitors Association. If they exhibit to a distributor or if he exhibits it among its own association members, then it is exempt. And entry number 47, there is a limit. Admission. Your right to admission, your ticket, there are charges. If it is not up to 500, it is exempt. If you pay more than 500, you are paying more than 500, then it is exempt. And it is taxable. So read them carefully anyway. And wherever, if you feel like having clarification, feel free to send a mail. Of course, you have my email ID, CALS. You can send a mail to CALS